Jefferson County Court at Law number 2 is now in session with the court's arraignment docket, which was scheduled for 9 a.m. on today's date of October 4th of 2022. Good morning, ladies and gentlemen. Okay, my name is Judge Terrence Holmes. I'm the judge here in County Court at Law number 2. You have been asked to come to court today because you have a case in this court. Your case is set on what is called an arraignment docket. What the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have is a criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are your most serious type cases, and your misdemeanor cases are referred to as petty offensive, but that does not mean that they are not serious. It just means that they are not as serious. And when I talk about something being serious, we're talking about the punishment range. That is what you can get as punishment for the offense that you're charged with. So for example, for a felony offense, felonies are divided into 5 categories. You have your capital murders, first-degree felony, second-degree felony, third-degree felony, and state jail felonies. If you are convicted of a state jail felony, the range of punishment is a minimum 6 months to 2 years in the state jail, a fine up to $10,000. If you're convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine up to $10,000. If you're convicted of a second-degree felony, the range of punishment minimum 2 years to a maximum of 20 years and a fine up to $10,000. If you're convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine up to $10,000. Now, if you're convicted of a capital murder, the range of punishment is life or death. Now, this court does not handle felony cases. Your case is not a felony case. Your case is a misdemeanor case. Misdemeanor cases are divided into 3 categories. You have your class A misdemeanor, your class B misdemeanor, and your class C misdemeanor. Class C misdemeanors are normally handled in the JP court or the municipal court, which is the city court. We handle class C misdemeanors only when they are appealed from the JP court or the misdemeanor court. Now, if you have a class C misdemeanor, the range of punishment is a fine only. You cannot be given any jail time. You only can be given a fine. So for example, a class C misdemeanor is like a speeding ticket, not having a seatbelt on, or cases like that. That's normally in the JP court or the city court. If you are convicted of a class B misdemeanor, the range of punishment is minimum 0 days to maximum to 180 days in the county jail and or a fine from $0 to $2,000. Or you could be given both such fine and confinement. Now, if you're convicted of a if you're convicted of a class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, a fine from $0 to $4,000, or you can be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. One of the rights that you have is a right to have an attorney. Now, the paperwork that's been handed out on the clipboard, it speaks to you about one of the rights that you have, and that is the right to have an attorney. Now, concerning your right to have an attorney, you have 3 options regarding your right to have an attorney. And number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number 3, you may represent yourself. If you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. And I think one of the last document that you have on that clipboard is the questionnaire. The financial questionnaire is titled Affidavit of Indigence. Now, you may not speak to the, now, if you desire to represent yourself, you may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. And the written waiver is the second page that's on the clipboard. And a waiver is you saying, I know I have a right to have an attorney. However, I'm waiving or I'm giving up my right to have an attorney, and I desire to represent myself. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Now, at the bottom of that document, it states in bold print, defendant's choice, mark initials next to only one choice. Now, if your choice is, I want to reset my case to hire my own attorney, then you'll place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to request an attorney or I want to apply for a court-appointed attorney, then you'll place your initials on the third line to the left. Now, if you've already been appointed a court-appointed attorney in your case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if your choice is, I want to waive my right to an attorney and represent myself, then you'll place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line at the bottom where it says defendant, and you will date it today's date, October 4th of 2022. Now, for those of you who will be waiving your right or giving up your right to an attorney and representing yourself, then you would have to read and sign the next document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And it states, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 4th day of October of 2022 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, then you will sign on the line that's titled defendant, and you will date it today's date, October 4th of 2022. Now, besides your right to have an attorney, you also have other rights. One of the other rights that you have is a right to have a trial by jury. And what that is, what a young lady is sitting in that area over there, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors in your case. And after listening to all of the evidence, they will deliberate and then decide whether or not you're guilty or not guilty. Now, you also have a right to waive your right to have a trial by jury or give up your right to have a trial by jury. And by doing so, if you waive your right to have a trial by jury, then your case will come before the court or come before the judge in one of three ways. One way it can come before the judge is by way of a trial, and we call that a bench trial. That means this is trial by judge only. You don't have a jury trial. The other way that it can come before the judge is by way of a agreed plea bargain agreement. A plea bargain agreement is an agreement that you and your attorney have worked out with the district attorney's office to settle your case. We call that a plea bargain agreement. If you have an agreed plea bargain agreement, y'all have come to an agreement, then the case will come before the court or before the judge, and the judge will decide whether or not to follow, which means to go along with the plea bargain agreement or not go along with the plea bargain agreement. Now, if the judge does not go along with your plea bargain agreement that you have reached with the state, then you have the right to withdraw your plea or to take your plea back if the judge does not go along with your plea bargain. Now, if the judge does go along with the plea bargain agreement, if you decided within 30 days that you would like to appeal your case, that is, you would like to have a higher court than this court to look at your case to see whether or not this court has committed an error by convicting you, or whether or not you have been unjustly convicted, then that case will go to the Ninth Court of Appeals, which is right above us. And they can either grant or deny your appeal. If they grant your appeal, you'll be entitled to either given a new trial, or they can send the case back down here, or they could just acquit you, find you not guilty. Now, if they deny your appeal, then what can happen then is you can appeal it to a higher court than them. So you can go higher. And that higher court is the Texas Court of Criminal Appeals, which is the highest criminal court in the state of Texas. They're located in Austin, Texas. Now, in order to appeal your case from the Ninth Court of Appeals, you would have to file what is called a pro se petition for discretionary review. Pro se means on your own without a lawyer. You'll be filing it on your own, and you'll be asking the Court of Criminal Appeals to see whether or not your appeal should have been granted, whether or not you've been wrongfully convicted, or whether or not this court committed an error by convicting you. They can either grant your petition or they can deny your petition. If they grant your petition, they can just find you simply not guilty, or they can send the case back down to this court in order this court to give you a whole new trial. Or if they deny your petition, then that's the end. In essence, your case is over. Your conviction will stand. Now, just to recap, as I said earlier, you have a right to, one, have an attorney. Two, you can waive or give up your right to have an attorney. You can, or you can represent, or you can ask for a court-appointed attorney. Or your case, you have a right to have a trial by jury, and you have a right to waive or give up your right to have a trial by jury. Now, if you waive your right to have a trial by jury, your case can come before the court in one of three ways. And the last way I was telling you was it can come before the court by way of a bench trial. That's by judge only, or it can come by way of an agreed plea bargain agreement. Now, the other way it can come before the court is by way of an unagreed plea bargain agreement. What that basically means is that you and your attorney have talked to the state district attorney's office, and y'all have not been able to reach an agreement to settle your case. So you want the judge to decide what your punishment is going to be. We call that an unagreed plea bargain agreement. Okay. Now, the other right that you have is you have a right to have witnesses to come to court. In that chair right there, where the microphone is, we call that the witness stand. And what witnesses do, they come to court and they can testify either for you or against you. And if you're representing yourself or if you have an attorney, you have a right to ask some questions. We call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses to come. By waiving or giving up your right to have witnesses, that simply means that you will not be calling, you and your attorney will not be calling witnesses in your case. However, that does not mean that the state will not be calling witnesses in your case. Because the state has filed the case, the state will be calling witnesses in your case. Now, you also have a right, a Fifth Amendment right against self-incrimination. And I know sometimes we look at television, we see people on television say, I take the Fifth. And what that basically means is with the Fifth Amendment right against self-incrimination, you have a right not to testify in your case. You have a right not to say anything that will incriminate you, okay? And so the state of Texas, the district attorney's office cannot force you to testify against yourself. If you say, I'm not testifying, I take the Fifth, then you have a right not to testify in your case. Now, you also have a right to waive or give up your Fifth Amendment right against self-incrimination. And by waiving or giving up your right against self-incrimination, your Fifth Amendment right against self-incrimination, that simply means that you will be testifying in your case, okay? Now, the other right that you have a right to have discovery. Discovery means you have a right to see the evidence that the state has against you. For example, they have a video, if they have tape recordings, if they have documents, witness statements, instruments, whatever they seize as evidence, you have a right to have access to that evidence, okay? Now, you also have a right to waive or give up your right to have discovery, which means you have a right to say, I don't want to have access, I don't want to see the evidence, I don't want to have access to the evidence, all right? Now, everyone here that's here for arraignment, you're here because you're out on bond. And you're either out on a cash bond, meaning that you paid cash money to get out of the jail, the full amount, or you're out because you're out on what is called a surety bond. And what a surety bond is, you paid a bondsman a portion of what was owed on the bond to get out. You paid him a percentage of it. Or you're out on what is called a PR bond. We call it a PR bond. It means that it's a personal recognizance bond. You didn't have to pay any money. You're out on a PR bond. Now, the reason why I brought that up is because every day that you spent in jail on your case, you can get credit toward your punishment. For example, if you spent 5 days in the Jefferson County Jail and you and the state has talked and they're agreeing to, y'all reach a plea bargain agreement where they're going to give you 5 days in jail, that means that you won't have to do any more time in jail. Why? Because you've already served 5 days in jail, therefore you'll be given credit for time served. Now, if they offer 7 days in jail and you did 5 days in jail, that means you have to do 2 more days in jail on your case. Now, every day that you spent in jail, you also get credit at $100 per day toward your fine and court costs. So if you spent 5 days in jail, that's $500 that can go toward your fine and court costs. So if the state is offering you fine and court costs of $500, that means you won't have to pay anything because the 5 days that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired, which means you won't have to pay it. Why? Because you've already paid it off by sitting in jail for the 5 days. Now, if they offer fine and court costs of $700, that means you would have to pay $200. Now, you'll be required to pay $200 on the day of the plea. If you cannot pay the $200 on the day of the plea, then the court can allow you to pay it off in installments. In essence, they could put you on what is called a payment plan. And now, let's say even if they put you on a payment plan, because of your financial situation, you still will not be able to pay it. Well, no problem, because the law allows the court to convert your fine and court costs to community service. In essence, you'll be working at a nonprofit organization in the local community. Now, every hour that you work at the nonprofit organization, you will receive $12.50 that will go toward your fine and court costs. So if you work 8 hours, you work 8 hours at a nonprofit organization, then that's $100 that will go toward your fine and court costs. Now, Jefferson County District Attorney's Office has a program that is called pretrial diversion. Pretrial diversion. And what that is, it's a program for first-time offenders where the state will dismiss your case, put you in the program, and if you complete the program, you can get it wiped off your record. We call that expunged from your record. It'd be wiped off, deleted, or erased from your record. And in order to get into the program, one, you have to be a first-time offender. Two, it cannot be an offense involving resisting arrest or unlawful carrying a weapon. And three, you have to have an attorney to assist you to write the application, to make the application, or to file the application to get into the program. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office has a program that is called Veterans Court. It is part of the pretrial diversion program. The same thing like pretrial diversion. You get into the program, case dismissed, complete the program, you can get it expunged, erased, deleted, wiped off from your record. The only criteria to get into that program is to be a veteran of any one of the branches of the United States military. Okay, that's called Veterans Court. Now, if you're interested in any one of these programs that I just mentioned, just let the court know, and then we'll be happy to assist you or happy to direct you to the person that you need to talk to so that you can get into the program with the District Attorney's Office. Now, this court has a program that is called the Community Safety Initiatives. Community Safety Initiatives, I normally refer to as the CSI program. That program is a program that I started within the first 100 days of taking office. With that program, we have partnerships with local agencies. One of the agencies that we have a partnership with is Spindletop Center. Spindletop Center is our local mental health center. What Spindletop will do is they'll come in, they will conduct private interviews. They can do an assessment, they can develop a treatment plan, either outpatient or inpatient treatment, to address any mental health need that you have. Now, you do not have to be insane or incompetent to be in the program. You could be a problem who suffers from anxiety, depression, post-traumatic stress, ADD. You can suffer from bipolar, schizophrenia, any one of the host of mental illnesses that there are. Spindletop can help address it for you. Now, we also have a program with Spindletop. Spindletop has a program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. And also with the Alcohol, Drug, and Abuse Council, they have a program that is called OZAR, stands for Outreach, Screening, Assessment, and Referrals. And both of those programs are drug treatment and drug treatment and alcohol treatment recovery programs. And the way the program work is, what they'll do, they can do a screening, an assessment, and then you could be referred to either outpatient or inpatient treatment to address any drug or alcohol issues that you may have. If you are unemployed or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in one of those areas, they will assist you at getting employment in the area that you're trained in. Now, if you have not finished high school and you would like to get your high school diploma, CICE also has a GED program where they can help you to get your high school diploma. All of these programs that I just mentioned to you are free. They do not cost you anything. Only thing you have to do is have a desire to be in the program. All of these programs that we have in the CSI program are designed to address the issue of what we call recidivism. Recidivism means when people commit crimes over and over. How do we address that? Well, County Court of Law addressed it through the CSI program. And with this program, we do not just arrest the problem, we address the problem. We do not just give time, we take out time. And we believe that we can produce productive people, and we believe that by producing productive people will not commit crimes because they have too much to lose. So I tell people this all the time: when you come to County Court of Law number 2, we do not have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And we're also trying to make a difference in the county in which we live. And so if you're interested in any one of these programs, just let us know. We believe that this community safety initiative, the CSI program, can make Jefferson County a safer place for all those to live, work, go to school, raise our children, and to go to church. Now, we will have Deputy Hinton is going to come forward. We have Deputy Hinton and Sarah there from Spindletop. I think Deputy Hinton is going to come forward and give you some information about the program that Spindletop has. At this time, I present to you Deputy Hinton.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I am a mental health deputy licensed by the state of Texas. I'm here with my colleague, Sarah. Sarah is a qualified mental health professional in Spindletop. The reason we are here this morning is because the judge has graciously invited us into his courtroom because he cares about every single person who comes before the bench. What the judge has found, and what statistics prove, is those who have legal issues in the criminal justice system commonly have either mental health, substance use disorders, or just a lack of community resources to help get you out of the cycle. Now, also, this may be your first time to be here. This may be your 10th time to be here. There's still hope. Sarah actually has a program that in place, a template, if you will, that can plug you in community resources to get you out of the cycle of arrest. There's just one thing we don't know. We don't know what's going on in your particular situation. So we're going to ask you to do something that may be a little uncomfortable. Maybe you wasn't prepared to do that. But we're going to ask you to share that need with Sarah or I when the court goes into recess so that we can help you and get you connected. All your information is private and will remain private unless you allow us to speak of it because of doctors or whatever may help you in your particular situation. Also have this flyer here. This flyer tells you a little bit on the backside about what we do, why we're here, and some of the benefits associated with engaging in this particular program. But on the front, it also has a 1-800 number. That number is a crisis hotline number. Should you ever find yourself in that same place, you can call that number and get help immediately. We're going to get this out to everyone before you leave here today. There's also a demographic form that tells us a little bit about who you are. We're going to get this to you. If you already have it, we're just going to ask you to fill that out, give us the information that we need to contact you. This may not be the best setting for you to visit with us. We get that and we understand. We know confidentiality is very important and we want to respect that. But we will follow up. If you'll give us a phone number, we will follow up with y'all, call you and see what we can do to help you if you will share that need with us. Does anyone have any questions? Thank you, Your Honor.
Okay. Now, ladies and gentlemen, the paperwork that has been passed out to you, if you need any assistance in filling out the paperwork, we have our court staff who is here to give you any assistance with filling out the paperwork. Now, the staff is going to come by with you, meet with you individually, to make sure that the paperwork is filled out properly. And then the court is going to ask each person to come up before the bench one at a time. And then we're going to put you in the category if you're hiring an attorney, if you want to hire an attorney, you want to see if you qualify for a court-appointed attorney, or you want to waive your right to an attorney to represent yourself. So that's going to take a little time. But at this time, the court is going to be in recess to give us time to get the paperwork from you. And if you need to use the restroom or anything, It's right out there in the hallway. I think the female restroom is on the far end of the hall, and the male restroom is closer to County Court at Law number 3, which is next door. Okay? Okay, and I think the female restroom is right across from 172nd District Court, which is right across the hall. All right. So at this time, the court will be in recess to give us time to get the paperwork from you.